The Medicaid mistakes that can cost families thousands. If someone in your family is over 65, or you are the one who might need long-term care someday, I need you to stop whatever else you are doing for the next few minutes and stay with me. Because right now, families are making Medicaid decisions that feel completely harmless in the moment and end up costing them months of ineligibility or a piece of the family home years down the road. And most people I talk to have either never heard of these 5 traps or they have heard the words without understanding the one specific action that actually keeps them safe. I am not talking about theoretical risks. I am talking about real penalty periods, real dollar amounts, and real deadlines that are either already ticking right now in your family's financial history or waiting to be triggered by a decision nobody thought twice about. Why you should stay updated. Make sure to hit subscribe and turn on notifications right now, because every week I cover the real financial information that affects seniors directly. The rules that changed, the protections you already qualify for, and the steps that actually make a difference. This is exactly the kind of content I put out every single week, and you do not want to miss it. Now let's get into it. The 5 Medicaid traps families need to know. Trap 1 is the single biggest misunderstanding in this entire system, and it sets up every mistake that follows. Trap 2 involves gifts and transfers made years before anyone even applies, and one specific 5-year window that most families do not know they're inside of. Trap 3 is the one that quietly drains a healthy spouse's savings when it never needed to happen. Trap 4 is the trap almost nobody sees coming because it does not happen while anyone is alive. And Trap 5 is the mindset that turns a fixable mistake into a permanent one. 5 traps, 5 actions. Let us start with the misunderstanding that catches more families than anything else. Trap 1, thinking Medicare has you covered. I want you to think of the specific person in your life this applies to right now. A parent, a spouse, maybe yourself. If a nursing home stay ever becomes necessary, I want you to know exactly what you are and are not walking into. Financially, Medicare and Medicaid sound almost identical, and families use the names interchangeably, constantly. They are not the same program, and the difference is the first trap. Medicare is federal health insurance, built around acute care, hospital stays, doctor visits, short-term rehab after an injury or surgery. It covers up to 100 days of nursing home rehab following the qualifying hospital stay, and even that comes with cost sharing after the first 20 days. What Medicare does not cover is custodial, long-term care, the day-to-day help with bathing, dressing, eating, and moving around that most nursing home residents actually need for months or years. That gap is where families get blindsided. Mom breaks a hip, goes to the hospital, gets sent to a nursing home for rehab, and everyone assumes Medicare is paying for the whole stay. Once that 100-day window closes, if she still needs care, the bill lands entirely on the family, unless Medicaid is already part of the plan. The action step: know which Medicaid category applies. Here is exactly what to do about this today. Find out which of the 3 Medicaid long-term care categories would actually apply in your family's situation. Nursing home Medicaid, home and community-based services, waivers for care at home or in assisted living, or regular Medicaid for lighter assistance. They have different rules, and only 2 of them carry the 5-year look-back we are about to cover in Trap 2. Knowing which one applies before a crisis hits changes every decision. Trap 2, gifts and transfers inside the 5-year look-back. Gifting money or assets too close to applying. This is the trap that catches the most families, and it almost always comes from a place of love, not carelessness. A parent wants to help pay for a grandchild's tuition. A father wants to sign the house over to his son to keep things simple. It feels generous and completely harmless. But if a Medicaid application follows within 5 years of that gift, it can undo the entire plan. Here is exactly why. When someone applies for nursing home Medicaid or an HCBS waiver, the state does not just look at what they own today. It reviews financial records going back 60 months, 5 full years before the application date. That is called the look-back period, and it applies in 49 states. California is currently the exception, but even that exception is closing, with its look-back period being phased back in during 2026. I want you to understand how broad the definition of a gift is here, because this is where families get caught off guard. It is not just signing over a deed. It includes cash gifts to family members, help with a grandchild's college costs, and here is the part almost nobody explains correctly: the IRS annual gift tax exclusion, which lets you give up to $19,000 per person this year without reporting it to the IRS. Does not protect you from Medicaid. Those are two completely separate systems. Gifting under that tax-free limit will still trigger a Medicaid penalty if a long-term care application follows within 5 years. And the penalty has no cap. The state calculates a penalty period, a stretch of time where Medicaid pays nothing, based on how long the gifted money could have covered care. Give away $100,000 in a state where nursing home care runs $10,000 a month, and you are looking at a 10-month penalty paid entirely out of pocket. The action step: review the last 5 years of transactions. Here is exactly what to do right now. Sit down and think back 5 years. Has there been a large cash gift, a property transfer, or anything sold for less than it was worth? If a family member has been providing care, was there ever a written caregiver agreement spelling out duties, hours, and pay? Or was it informal cash that could read as a gift instead of compensation? If any of those things happened without documentation, do not wait for an application to get denied to deal with it. A certified Medicaid planner or elder law attorney can often find legitimate exceptions, transfers to a spouse, or the caregiver child exemption for a home that make a past transfer penalty free. And know this: spending money on legitimate expenses, home repairs, medical bills, paying off debt, prepaying funeral costs, is not a gift and does not trigger a penalty, even though it lowers countable assets. The line between a smart spend down and a disqualifying gift usually comes down to documentation and timing. Trap 3, leaving the healthy spouse financially exposed, forgetting to protect the spouse who stays home. This one is heartbreaking because it is entirely avoidable, and it happens the moment one spouse needs nursing home care while the other is still healthy and living independently. The instinct is to assume that if one spouse needs Medicaid, the couple has to spend down nearly everything they own together before the state helps. That is not true, but plenty of families do not find that out until they have already liquidated savings they never needed to touch. Medicaid treats a married couple's assets as jointly owned, no matter whose name is on the account. But there is a federal protection built specifically for this, called the Community Spouse Resource Allowance. It lets the healthy spouse keep a set amount of the couple's combined assets, separate from the $2,000 limit the applying spouse must meet. This year, that protected amount runs up to roughly $162,660 in most states, though some states set their own lower maximum. The action step: calculate spousal protection before applying. Here is exactly what to do. If one spouse is heading toward needing long-term care, get the couple's full asset picture in front of a Medicaid planner before submitting any application, not after. There are legitimate ways to shift assets toward the community spouse and structure income so the healthy spouse is not left financially exposed. This is one of the clearest cases where getting the sequence right, planning before applying instead of after, changes the entire outcome. Trap 4, forgetting about estate recovery after death. This is the trap nobody warns families about, because it does not happen while the Medicaid recipient is alive. It happens after they die. Every state runs a Medicaid estate recovery program, and once a Medicaid recipient, who is 55 or older passes away, the state is required by federal law to try to recoup what it spent on long-term care from whatever is left in the estate. A home is generally treated as an exempt asset while someone is alive and on Medicaid, which means it is very often the only asset of real value still sitting there at death. The house families assumed was safe is frequently exactly what the state comes after. There are real protections here, and I want you to know them. The state cannot pursue estate recovery while a surviving spouse is alive. It cannot recover if there is a child under 21 or a child of any age who is blind or permanently disabled, and it cannot collect more than it actually paid out. Some states can even place what is called a TFRA lien on a home while someone is still alive if they are considered permanently institutionalized. That does not force an immediate sale, but it does mean the state gets paid first whenever the home is eventually sold. And states typically only have about a year after death to file a claim, which means some families assume they are in the clear simply because time passed, when a claim might still be pending. The action step: understand your state's estate recovery rules. Here is exactly what to do. Do not assume the house is untouchable just because it was not counted against Medicaid eligibility while your parent was alive. Ask an elder law attorney about your specific state's estate recovery rules early, ideally years before care is ever needed. Certain irrevocable trusts, life estates, or a qualifying transfer to a caregiving child can take a home out of the state's reach, but nearly all of these only work if they are set up well before an application is filed, not scrambled together afterward. Trap 5, trying to DIY complex asset protection. The last trap is less about one rule and more about a mindset, treating Medicaid planning like something you can figure out yourself over a weekend with a search engine. This is where the first 4 traps stack on top of each other. Someone sets up a revocable living trust thinking it shields assets from Medicaid, not realizing that because they still control the assets inside it, Medicaid counts it exactly as if they owned it outright. Zero protection. Someone else moves money into an irrevocable trust without realizing the transfer itself starts the 5-year look-back clock. So if care is needed sooner than that, they have created a penalty instead of avoiding one. Someone pays a family member in cash for caregiving with no written agreement, and the state treats it as an unexplained gift. Individually, any one of these is fixable with the right guidance. Stacked together, they can turn a Medicaid application that should take weeks into a denial that takes years to untangle, while the bills keep coming. The action step: get professional help before a crisis. Here is exactly what to do. This is the point where professional help pays for itself many times over. A certified Medicaid planner or elder law attorney does this full-time, knows your state's specific rules, and can spot a 5-year-old transaction that would otherwise sink an application before it is even filed. The earlier you bring one in, years before care is needed, not weeks, the more legal options are actually still on the table. Final checklist: 3 questions to ask this week. Let me bring everything together right now in the simplest way I can, because everything we covered today, Medicare's gap, the look-back period, the spousal allowance, estate recovery, DIY trust, all of it comes down to one theme: timing. And I want you to check 3 things before this week is out. Number 1, has anyone in your family made a large gift or property transfer in the last 5 years? If so, get it in front of a Medicaid planner now, before it ever becomes part of an application. Number 2, if a spouse might need care soon, has anyone calculated the community spouse resource allowance for your state and structured assets accordingly? If not, that conversation needs to happen before any application is filed, not after. Number 3, does your family know your state's specific estate recovery rules, and is the home currently exposed? If you do not know the answer, that is the call to make this week. 3 questions, 1 conversation, with a professional that is what stands between your family and any of these 5 traps.